All right, cool, all rise.
So, point two.
Point two. Point two is that the starting point, and indeed in most cases, the finishing point for the ascertainment of the purpose of an enactment is the statutory language itself. And I apologise for labouring what may seem an obvious point, but I do say that it can't be overemphasised in circumstances where what's mounted against the respondent is an argument based upon the general law of occupational pension schemes. And it may be helpful, and I think my learned friend Mr. Giffen was going to do this before lunch if you had time, just to have a look at Spath Home.
Yes, he was. But I stopped him because I sent him off on a tangent of my own devising, but I knew we'd get to look at it anyway.
So tab 3 of the primary authorities bundle. And I say that the general approach which should be taken is usefully encapsulated at the beginning of Lord Nicholls' speech. So perhaps I'll pick it up there, which is at page 396, starting at 396E.
Sorry, what's the MS number?
I'm so sorry, 515.
Thank you.
The purpose for which a power is conferred, and hence its ambit, may be stated expressly in the statute, or it may be implicit. Then the purpose has to be inferred from the language used, read in its statutory context, and having regard to any aid to interpretation which assists in the particular case. In either event, whether the purpose is stated expressly or has to be inferred, the exercise is one of statutory interpretation. Statutory interpretation is an exercise which requires the court to identify the meaning borne by the words in question in the particular context. And we say that is the exercise upon which this court should be engaged here. Now, Spath Home was, of course, concerned with the regulation-making power contained in a consolidation statute, so it raised particular issues of whether it was permissible to look at earlier provisions dealing with the same subject matter. But what the House of Lords said about the interpretation of consolidating legislation is also, I think, more generally relevant to the question whether it's appropriate to cut down wide statutory language by reference to what is assumed to be a single statutory objective. And it's helpful to see in my submission the approach of Lord Bingham giving the leading judgment. And perhaps I can pick this up at 381B of the report, which is 500 MS page. And one sees him identifying the main issue in the appeal at B, which is the scope of the order-making power conferred by the Landlord and Tenant Act 1985, and in particular, in Spath Home. Did it have to be exercised in order to counter inflationary difficulties, or could it also be exercised more generally in the interests of the well-being of tenants? And he identifies at 381F the starting point, which is the language of the section itself. And if one then scrolls over onto 382C, so page 501 MS, he says you can't discern a specific unifying scheme in the legislation. I don't find, studying the language of section 31, that it's in any way ambiguous or obscure, or such as to lead to absurdity if given its full apparent effect. So he starts by framing the issue of the analysis of the width of the statutory language and asks if there's some reason for departing from it. And counsel for Spathholm then makes the submission that the language is on its face very broad, and faced with that, certain presumptions should be applied. One sees that at letter E. And having dealt with that, Lord Bingham disagrees, 384D, is not persuaded that section 31 is ambiguous or unclear, or that it should receive any construction not based on what appears to be its clear meaning, but nevertheless says that he's left with a sense of unease springing from the lack of a specific purpose, and it's that unease that leads him to consider that it's proper to look at the predecessor enactment in order to ascertain statutory purpose. So he then goes on to have a look at section 11 of the Housing Rents and Subsidies Act 1975, and the argument made to him about that by Spathholm is, well, the 1975 Act is all about inflation and only about inflation, and the background was fear of inflation. So, therefore, the consolidating power should be looked at in the same way. And Lord Bingham says, well, even on its own terms, that argument fails, looking at section 11 of the 1975
Wait, where are you reading
Act.
now?
So I'm now looking at 390. 390, which is page 509 of the MS. And at C, he says the more difficult and for present purposes more crucial question is whether anti-inflationary purposes were the only purpose for which the section 11 power could be lawfully exercised. A number of considerations lead me to conclude that the power could in appropriate circumstances be used for other purposes as well. And those reasons 1, 2, 3, and 4 are then enumerated there. And they are focused on the language of the Act, in essence. Language of the Act of 1975 was not expressly and exclusively directed to countering inflation. Point 2 didn't provide powers exercisable should cease to be exercisable after the expiration of a specified period. Point 3, if Parliament had intended to restrain the exercise of the Section 11 power save for the purpose of countering inflation, it would have been very easy for it to say so. And then going over onto 391 and sort of wrapping up the argument on Section 11 of the 1975 Act, what he says there, and it's just above B, is to say to treat countering inflation as the sole mischief at which Section 11 was directed is to fall into the fallacy identified by Lord Simon and Lord Diplock of treating a single identified mischief as the only mischief. And that's a reference back to a passage from Maudsley and Ollins that he cited at page 385 of the report, so page 504 MS. And one sees it by letter F. For a court of construction to constrain statutory language which has a primary natural meaning appropriate in its context, so as to give it an artificial meaning which it's appropriate only to remedy the mischief which is conceived to have occasioned the statutory provision, is to proceed unsupported by principle, inconsonant with authority, and oblivious of the actual practice of parliamentary draftsmen. Once a mischief has been drawn to the attention of the draftsman, he will consider whether any concomitant mischiefs should be dealt with as a necessary corollary. So I say that's an important note of caution in seeking to constrain a widely expressed statutory power by reference to a narrow presumed purpose. And I accept, of course, that where a very wide power has been conferred, there may be an implied limitation upon it, referable to statutory purpose. And I accept that there's no such thing as an unfettered discretion. But I do also say that proper significance must be given to the fact that Parliament has chosen to express a power in wide rather than narrow language. And that leads me on to the third of my 6 propositions, which is that the relevant statutory language here is very wide, and the guidance is clearly within its natural meaning. And I can take this very swiftly because my learned friend Mr. Giffen took you to the relevant bits of the Act when he opened. But I say everything about the language of the Act shows that it is not narrowly focused solely upon the prudential management of a system of contribution and benefits. And if I can just, without having to turn it up, take you to what I say are the relevant provisions of the Act that establish that, even starting with the preamble, the Act is to make provision for public sector pension schemes and for connected purposes. And I emphasise, and for connected purposes. As one sees from section 1, it covers a wide range of schemes for persons in public service. And by Schedule 2 to the Act and section 2, a range of different ministers who are empowered to make regulations for such schemes as responsible authorities. And the framework of the Act has to work for all such responsible authorities and all such schemes. It's not just LGPS focused. Then section 3 of the Act is the enabling power, and that states that the responsible authority can make such provision in relation to a scheme under section 1 as the responsible authority considers appropriate. So a traditional formulation for a regulation-making power conferring very wide discretion. And indeed, the appellants rightly accept that this is a very wide power, and in fact positively aver that on its own it would have a virtually open-ended scope, and that's paragraph 75 of the skeleton. But I say that the width of the power is a matter to which significance should be attached. And that width is emphasised by subsection 2 of section 3, because there again, that says the regulation-making power includes any of the matters in Schedule 3, and also includes consequential, supplementary, incidental or transitional provision in relation to the scheme or any provision of the Act. So again, expressed in very wide terms, and specifically not restricted or limited to the particular administrative matters that may be included in Schedule 3. It's relevant to pause at section 4, I think. I'm not sure that Mr. Giffen did take the court to section 4 before moving on to Schedule 3. And that's at page 309 of the Core Authorities volume. Because that's the duty to provide for a scheme manager who's responsible for managing or administering the scheme. And we say it's important to note that by section 4, subsection 3, the scheme manager and the responsible authority may be one and the same. So it may be the Secretary of State. And one then comes to Schedule 3, starting at page 378. And again, I don't need to take you to it, which sets out the specific matters that regulations made under Section 3 can include. And one sees from paragraph 11, page 388 MS, just for your note, that scheme regulations can be made in relation to pension funds, including the administration, management, and winding up of pension funds. So again, expressed in very general terms. And by paragraph 12, can be made in relation to the administration and management of the scheme, including, by paragraph 12A, the giving of guidance or directions by the responsible authority to the scheme manager. So
all nuts and bolts, says Mr. Giffen. These paragraph headings. Process, says Mr. Giffen. What do you say about that?
Not surprising that it's expressed in terms of nuts and bolts when the primary purpose for which the Act exists is to ensure that people get the pensions that they are entitled to get by statute. Not at all surprising that insofar as it deals with specific things, it deals with nuts and bolts. But it is also careful not to cut down the regulation-making power by indicating it only deals with nuts and bolts.
You're saying one's got to read in that the possibility that the guidance may be given for the purpose of enforcing the UK's foreign policy.
Well, my Lord will know that that's not quite how I characterise the purpose of the guidance. But I do say that yes, guidance can be given under that rubric for the purpose of ensuring that when administering authorities invest, they do not invest for non-financial reasons in ways that run counter to the interests of the UK as a whole.
I mean, it's slightly odd. One would expect there to have been some involvement of the Foreign Secretary or the Secretary of State for Defence. I mean, these responsible authorities are just the authority, the Secretary of State who have to be responsible for that particular branch of government. Maybe the Lord Chancellor, maybe Secretary of State for local government or whatever.
Well, yes, I mean, I think, my Lord, that the Secretary of State may be taken to be representing the interests of the government as a whole for these purposes.
Yeah.
And one thing that Mr. Giffin didn't take you to, which I think it's also useful to turn up, is the explanatory notes, because those again emphasise the width of these powers. So if I can take you to page 422 of the Primary Authorities volume, MS page 422. It's perhaps relevant to pick it up at paragraph 8, because as one sees from the second sentence there, the point is that this Act has to create what's called a common framework of requirements, so common to all the various public sector pension schemes with which it's concerned, not just LGPS. Then, picking it up at page 423, under subsection 1 of section 3, scheme regulations can make such provision as the responsible authority considers appropriate, provided it is in accordance with the requirements set out in the rest of the Act. For examples of sections, and then the various sections are given which limit that power, then paragraph 20 says, the provisions which can be made include in particular, as subsection 2a says, any matter set out in Schedule 3. The schedule sets out a non-exhaustive list of matters which can be included in scheme regulations. If a matter is not mentioned in Schedule 3, this does not prevent it from forming part of such a scheme, provided it is within the powers given by sections 1, subsection 1, and 3, subsection 1. And one sees that inclusionary note, if I can put it that way, repeated when the explanatory notes come to the power under paragraph 12 of Schedule 3 itself. So that is now paragraph 223, first of all, on page 441. This schedule, so Schedule 3, contains a list of the type of provision that may, in particular, be included in scheme regulations made under Section 1. It's not an exhaustive list, but an indication of what can be included in scheme regulations. And then paragraph 235 on the next page, paragraph 12 provides a non-exhaustive list of the provision that may be included in regulations that relate to the administration and management of the scheme. So I say both the terms of the statutory provisions themselves and the explanatory notes are all about emphasising the width of these powers. And one then goes to the terms of Regulation 7 of the 2016 regulations themselves, which is at page 458 of your volume. And we say the impugned parts of the guidance are absolutely squarely within the language of Regulation 7 1 and 7.2e. And there's no dispute about that, but telling authorities that they may not use pensions policies to pursue boycotts, divestment, or sanctions against foreign nations is precisely to inform them how non-financial factors can be taken into account in the selection, non-selection, retention, and realisation of investments.
Well, does how mean what?
It includes, how social, environmental, and corporate governance considerations are taken into account includes, my lady, what type of social, environmental, and corporate governance considerations can be taken into account. And indeed, it would be very surprising if that wasn't the case, because, as my learned friend Mr. Giffen made clear before lunch, the guidance and the regulations were issued as a package. So that is my third proposition. My fourth proposition is that the guidances within what we say are the obvious relevant purposes of the Act and regulations. And we say there are three relevant purposes of the Act taken as a whole. One, which is the principal purpose of the Act, is to ensure that public sector workers receive appropriate pension provision, Section 1 and Section 3. The second relevant purpose is to ensure that scheme managers, including, for this purpose, LGPS administering authorities, have responsibility for managing or administering schemes, Section 4. And the third purpose is to allow the Secretary of State, as responsible authority, to give scheme managers guidance on anything to do with the lawful management or administration of the scheme, Section 3 and Schedule 3, Paragraph 12. And we say the part of the guidance dealing with non-financial factors, which is attacked by the appellants, is entirely consistent with all three of those purposes. First of all, under the guidance, the primary duty imposed upon administering authorities, to which any decision to take into account non-financial factors is subordinated, is the duty to make a financial return the predominant concern. And in the context of a funded scheme, that properly reflects the duty to ensure appropriate pension provision in Section 1 of the Act. Guidance is fully consistent with that overarching purpose. So to come back to disinvestment in a particular country, if that carried a significant risk of financial detriment, it couldn't be done. And equally, if it was more financially advantageous to invest in that country than not to invest in that country, if the pension fund would do better as a result, then should be done. And it's only in the middle ground, non-financial factors, that the guidance, the impugned parts of the guidance take effect. And we say the impugned parts of the guidance are also consistent with Section 4, because what the guidance does not do is it doesn't remove scheme managers' ultimate responsibility for managing schemes and making appropriate investment choices. Because insofar as the guidance deals with boycotts, divestments, and sanctions, it still leaves scheme managers free to decide what investment choices to make. It doesn't require them to invest in a particular class of asset, doesn't prohibit them from doing so either. It simply forbids them from adopting an investment strategy that is run according to certain specific non-financial factors. So we say, consistent with leaving ultimate decisions in the hands of scheme managers, and that's what Section 4 requires. And finally, we say it promotes the third obvious purpose of the Act, which is to allow the Secretary of State to give scheme managers guidance on anything to do with the lawful management or administration of the scheme. And if one aspect of lawful management is making decisions on whether to adopt non-financial investment criteria, and if so, what those criteria should be, then giving guidance on that aspect, we say, promotes the purpose of the Act. It is squarely within the Act's purposes. And provided that the guidance allows scheme managers ultimate responsibility for investment decisions, and it does, we say there's no reason why it should not also ensure that when scheme managers take non-prudential decisions on investment, they do so in ways which the government considers are to the wider public benefit. And the width of the language of the Act, in my submission, implies that general public benefit considerations of this type are matters with which guidance can properly be concerned, provided that they're consistent with the primary purpose of the Act of making pension provision.
Could I just ask you, apropos that, I'm a bit puzzled. Do each of the categories of people whose pension schemes are governed by this Act have a statutory right to a pension which depends upon some anterior legislation to this? We were told that that was true of the local government pension scheme. Their entitlement to pension comes from other legislation, and certainly that's true of the judiciary. Our entitlement to pensions comes from other legislation than this. So that the actual entitlements are located elsewhere. This is about how you manage and administer those entitlements.
Well, the entitlements, my lady, are to be found in scheme regulations as defined by Section 28, because one sees from Section 28 of the Act, and it may be helpful just to turn it up. I mean, the previous, and the entitlement is contained in other pension scheme regulations, but by Section 28, those become regulations made under the Act. So, yes, the entitlement is not set out in the regulations with which we are concerned, but it is set out in regulations that are deemed to be made under the Act.
Yes, but the thing that says that local government officers are entitled to pensions, doesn't that come from somewhere else?
Well, I mean,
I'm just a bit puzzled about the relationship with this legislation and other legislation. And it's prompted by, I mean, judicial entitlement to pensions comes from legislation giving them a right to a pension, either a 1981 or 1993 Act.
Unfortunately, for those who are a bit younger.
Is it? Oh.
I think that's right. But no doubt it can be checked. It's not true at all.
Yes. Well, this is all I'm trying to get at is
I mean, my lady,
what the sense of the source of the entitlement is.
Yes. I mean, I think the answer is that, you know, if one
Maybe
were
different.
looking back to, let's say, 2000, the entitlement would have been in scheme regulations made under Section 7 of the Superannuation Act 1972. But now the entitlement is in scheme regulations because whatever has been made under the 72 Act is deemed to be made under the 2013 Act instead.
Thank you.
Yeah, I'm a little puzzled myself, but anyway, it doesn't matter, but it would be quite helpful to have that clarified. My understanding was that the judicial pensions are covered either by the earlier Act or the 93 Act,
but they may have changed the whole basis subsequently, which they probably have. But that's why I was asking, because quite clearly for those who are entitled under other legislation, this may be dealing with how you administer that entitlement, but it's not dealing with the entitlement.
Yes. Yes, I mean, in this case, my lady, I think the answer is that yes, it is dealing with entitlement, and that's Section 1 and Section 3 of the Act, as read with Section 28, which brings in 2013 Local Government Pension Scheme regulations. So, my lady, I think I was about to address you on what I said was my fifth proposition, which is that the Secretary of State's position on statutory purpose is consistent with the wider context of the Act. And I have 2 points to make here. The first point is that the Act provides powers for ministers to create a wide range of public sector pension schemes according to a common framework of requirements, and that framework needs to work for all schemes under the Act. It applies both to funded and unfunded schemes, and to schemes where the minister is the scheme manager under Section 4, and where the minister isn't the scheme manager, as here. And in fact, in the majority of schemes under the Act, the responsible authority and the scheme manager are one and the same, i.e. the relevant Secretary of State. And that's the case for schemes in relation to the armed forces, to the civil service, to the judiciary, of course, to health service, and to teachers. Now, I mean, as it happens, all those schemes are pay-as-you-go schemes rather than funded schemes. So there's no ring-fenced fund, employee contributions paid into consolidated fund and benefits paid out of the fund as appropriate. And obviously in such cases, there's no investment rule that limits the way in which employee contributions are treated, because the thing that matters is that the employee receives appropriate benefits out to the other end, having made their contributions. But even supposing for a moment that such schemes were funded, we say there would be no basis for requiring the Secretary of State as scheme manager to adopt certain non-financial factors simply because they accorded with the wishes of scheme beneficiaries. Because if the Secretary of State is the scheme manager, by definition, he or she could ensure that to the extent that investment decisions were taken for non-prudential reasons at all, they weren't taken in ways that the Secretary of State considered to be contrary to the public interest. And I do say that that illustrates that where the responsible authority and the scheme manager are different, as they are in the case of the LGPS, there's no reason why it shouldn't be a secondary purpose of the Act to ensure that the scheme manager doesn't act in a way which the Secretary of State as responsible authority considers is contrary to the public interest. In fact, I say there's every reason why it should be a secondary purpose of the Act. So that's the first of my 2 points on context. And the second point on context is this. I say that there's nothing anomalous in the Secretary of State's approach to the public interest when you look at the general context of what is meant by giving public sector pensions, because the administration of public sector pension schemes is a matter of general public importance. It's beyond its individual significance to scheme beneficiaries. It involves the payment of a large amount of money from public funds, ultimately funded by the taxpayer. And that's just as true in the case of a funded scheme such as the LGPS as it is for unfunded pay-as-you-go schemes.
I suppose it's funded by the taxpayer in the sense that the salaries paid to public servants are funded by the taxpayer.
Yes.
As well as more directly through, if it's a funded scheme, the employer's contribution, which comes out of the employer's.
Indeed, my lady, in both of those senses, yes. So, exactly for the reasons that my lady has given, we say the interests of the taxpayer as well as scheme beneficiaries are engaged by the way in which funds are treated. And above and beyond that, the Secretary of State's evidence, so Chris McGaney's witness statement, which you've got in your core volume, makes the point at MS page 253, and it's the first bullet point under paragraph 13, that because administering authorities are themselves part of the machinery of the state, boycotts, divestments, or sanctions adopted by them may be correspondingly damaging to UK foreign policy and legitimate UK trade in a way that action by private providers wouldn't be. So, both for the sort of public interest funding reasons and for reasons of the perception that may be created when a particular policy is adopted by part of the machinery of the state, we say it's unsurprising that in those circumstances the statutory scheme should allow the Secretary of State to issue guidance to administering authorities that reflects the government's wider view of the interests of the UK as a whole.
And does it follow that when the government changes and there's a different view about Israel, about the settlements, that the guidance can change?
The guidance can certainly change, and it may be that a different government would take a different view upon the damage caused to foreign policy by adopting a particular BDS position. May well be, but those are decisions preeminently within the foreign policy expertise of government, and they're decisions on which more than one view can reasonably be taken.
Of course, the guidance might not change, but the policy might change.
Well, indeed.
The guidance could be exactly the same, but with a change of government, the policy could change, and then the scheme's got to behave accordingly.
Yes. Yes, I mean, just to round that out, I mean, the duty on administering authorities is to publish at least every 3 years a statement of their investment principles. And of course, if the guidance, there's nothing preventing them from doing that more often. And if the guidance changed and they wished to reflect that in the particular non-financial factors that they were going to take into account in investment decisions, then no doubt they could issue a new statement of investment principles. So that's my fifth proposition. And the sixth proposition is based upon the structure of the regulations, because we say once the appellants have accepted that under the regulations they can legitimately take into account non-financial factors in investment decisions, we say it must follow that the Secretary of State is equally entitled to give guidance on those factors. So if I can flesh that out, it's clearly implicit within Regulation 7, subparagraph 2, subparagraph E of the regulations, that administering authorities can take into account non-financial factors in the selection of investments. And therefore, if an administering authority decides, for example, to disinvest from tobacco in circumstances where there's no financial detriment, they're not acting outside the purposes of the statutory scheme. and there may be a number of other reasons why they couldn't adopt a particular non-financial policy, but they wouldn't be Padfield principal reasons. And it must therefore follow, we say, that the Secretary of State, as the responsible authority, is entitled to give guidance on how administering authorities pursue that purpose. There cannot, logically, be a mismatch between the sort of considerations that administering authorities might take into account when managing pension funds, therefore including an investment strategy statement, and the matters on which the Secretary of State is entitled to give guidance. Now, my learned friend says that my submission on this part of the case is that absent guidance, an administering authority would be entitled to pursue its own view of where the public interest lies. And I say that's not quite right. I say, absent any guidance, if you just had the Act and the regulations, it would be open to an administering authority to take account of any public interest considerations relevant to its own duties and functions in deciding what non-financial factors should be taken into account. Now, the views of members would, of course, be a relevant consideration, and that would be so even absent the guidance. But the range of permissible relevant considerations is not limited to members' views. It would include, and I'll come on to this shortly, for example, the public sector equality duty. It could include a range of other public law duties. And the reason why, assuming all that the authority's own view of foreign policy, assuming that this wasn't shared by its members, would not be a relevant consideration. It's because local authorities don't have foreign policy. I mean, that's, it's got nothing to do with Padfield as such. It's simply because a local authority's private view of whether or not boycotts should be imposed upon particular nations has nothing to do with its functions. Now, this is, as Mr. Giffen says, my case that if an administering authority can include non-financial factors in its investment strategy by reason of the regulations, then the Secretary of State must be able to give guidance on what those factors should be. It's a sort of you can't have your cake and eat it point. But the answer that Mr. Giffen gives to that is, well, because administering authorities act as fiduciaries, they are acting for a pensions purpose of giving effect to members' wishes when they take into account non-financial factors, and that doesn't apply to the Secretary of State. So that's the case that's put against me. And I say that that is an illogical distinction because it mischaracterizes the reason why it is within the purposes of the statutory scheme for an administering authority to take non-financial factors into account. And the reason is not because administering authorities have the fiduciary duties of trustees of private sector pension schemes. It's because non-financial factors are matters which can implicitly be taken into account under the statutory scheme, see Regulation 7.2e. And we say, for that very same reason, the defendant must be entitled to give guidance on them.
It's all part of the package.
It's all part of the package. Exactly. So, if the scheme, the package, allows administering authorities to take into account non-financial factors, if those are properly within the purposes of the package, we say it must also be within the purposes of the package for the Secretary of State to give guidance on those very same factors. So those are my 6 propositions, and that's why we say that the guidance is squarely within the statutory purposes of the Act and the regulations. But if I may, I'll just address you on the appellant's approach and some of the contentions in Mr. Giffin's written case and in the case that's been put to you this morning. And we say that there's a problem with the approach. There's a basic problem, which is that instead of starting with the language of the 2013 Act and the regulations, the appellants conduct a complex analysis of the duties of LGPS administering authorities, which aligns those duties with fiduciary duties of private pension scheme trustees, and then retrofits that analysis onto the scheme of the Act. And we say the first problem with that is that it artificially extracts an element of the package and elevates it to a governing principle. So it starts from the wrong place. And the only reason why the duties of administering authorities can be said in certain respects to be quasi-fiduciary is because that is what the package, the Act, the scheme regulations under it, provides for. And it's important to recognise that the LGPS is not a collection of trusts with each administering authority as a trustee. It's a statutory scheme. And the duties of administering authorities are not imposed upon them by general trust law. They're imposed by the statutory framework, the regulations, the Act. If I may, I might just take you to one case, which is Re Bain, which is tab 31 of volume 3 of the authorities. And that was a case about whether the members of the Superannuation Committee of Scottish Homes owed fiduciary duties to the employees and former employees of Scottish Homes, to the members of the pension scheme. And one can see...
Got a page reference?
1281, my lord, is where the case starts.
And what did you say the case was about? You see, I was waiting for the number.
Sorry, yes. It's a case about whether the members of the Superannuation Committee of Scottish Homes owed fiduciary duties to employees and former employees of Scottish Homes within the pension scheme. And you can see that from the opinion of the court, so starting at page 1282, that Scottish Homes as a body corporate is the successor to Scottish Special Housing Association, and it maintains a fund under the local government pension scheme regulations for Scotland. So 1113G, in terms of the 1987 regulations, so the relevant local government regulations, Scottish Homes was the administering authority and was in the same position as a local authority. And the issue raised by the case is stated at paragraph 9 on the next page.
Sorry, what's the page reference again?
So that's 1283, paragraph 9 on 1283.
Yeah.
The petitioners contend that the fund is held on trust for the members, pensioners and deferred pensioners. Scottish Homes stands in the position of employer. Petitioners are the trustees of the fund, and the fund is a trust scheme for the purposes of the 1995 Act. So that's the Pensions Act 1995. And paragraph 10, the court says, we begin by examining the proposition that the petitioners themselves are the trustees of a trust. The petitioners were the administrators of the pension fund. In our opinion, the proposition found is at the first hurdle, no deed. And then paragraph 11, so now 1284, MS page 1284, the substantial issue in the case relates to the proper characterisation of the scheme whereby Scottish Homes administer the fund. And one sees, if one goes forward to 1115L, the nub of the reasoning is that paragraph 14 are the circumstances of this case consistent with the interpretation of a trust, and in particular its creation. There's then some discussion of the fact that a public service pension scheme and an occupational pension scheme are definitions which are not mutually exclusive, but then when regard is had to the provisions of the 95 Act, a distinction is made between a trust scheme, which defines an occupational pension scheme established under a trust, and a public service pension scheme. The latter has the meaning given by Section 1 of the 1993 Act, and then it says, the scheme for which Scottish Homes is responsible as the administering authority is one established under an enactment, the 1972 Act, and all the particulars of the scheme are set out in a legislative instrument made under an enactment, namely the regulations made under the 72 Act, that's the Superannuation Act 72. It is therefore not a trust scheme, but a public service pension scheme. And that's sufficient to dispose of the submission. So, I mean, I do say Rebay makes an important point, which is that when you are looking for the powers and the relevant duties of administering authorities and of the Secretary of State as responsible authority, what you look to is the comprehensive statutory package. You do not look, we say, to trust law. And that's, we say, the first problem of approach. And the second problem of approach is that, in fact, the statutory scheme does not here impose duties upon administering authorities which are identical to those imposed upon trustees of private sector occupational pension schemes. Now, we accept that in some respects the duties of administering authorities can appropriately be characterised as quasi-fiduciary, in the same way as duties of local authorities towards ratepayers have been characterised as quasi-fiduciary in various well-known cases, Robertson, Hopwood, etc. But that principle has its limitations when one is seeking to draw an exact analogy between trustees and administering authorities. And one important limitation is that administering authorities are subject to public law duties, and those public law duties may not only entitle them, but oblige them to take decisions on non-financial factors which do not reflect the views of scheme members. And the example that I've given in the respondent's case is the public sector equality duty. I say that's an important example. Because among other things, as you'll be very well aware, it requires a public authority in the exercise of its functions, which would include investment functions, to have due regard to the need to foster good relations between persons who share a protected characteristic and those who do not, so persons of different races or nationalities. And one can easily imagine circumstances in which a substantial body of scheme members might wish an administering authority with, say, a large Jewish community to boycott Israeli investments to express disapproval of Israel's actions in the occupied territories. And the administering authority, being aware of that view of a substantial body of scheme beneficiaries, might legitimately conclude that a wide boycott of that type would be likely to alarm the Jewish community or to encourage anti-Semitic attitudes. I mean, that might, on the facts, be a rational conclusion to draw. And we say it would be entirely in line with its duties in those circumstances if it said it wouldn't adopt a boycott, even if it was supported by scheme members, and even if it created no significant risk of financial detriment to the scheme. So, when the appellants contend, as they do, that all an administering authority can lawfully do is act for the pension's purpose of giving effect to members' wishes, where that doesn't carry material financial risk, we say that's a mischaracterization. It leaves out a very important part of the jigsaw. I think I should also address, if I may, the Law Commission's 2014 report. So tab 4 of the core authorities bundle. Because we do say that on a proper analysis, this doesn't provide unqualified support, if I can put it that way, for the proposition that the same rules which apply to pension fund trustees in taking account of wider or non-financial factors also apply to the LGPS. And I wonder if I can pick it up at page 556 of the core authority. And it's paragraph 4.79. The first point on this paragraph is that the Law Commission says we think the same rules which apply to pension fund trustees in taking account of wider or non-financial factors will also be taken to apply to LGPS administering authorities. There is an argument that the IORP directive requires this. However, we think that uncertainty on this point is undesirable. Now, the first point that I would want to make is that the Law Commission itself observes that the position is unclear, uncertain, and the reason why it does so is because, as one sees from the next page, page 557, at paragraph 4.83, as the Law Commission itself observes, LGPS administering authorities are not subject to the same duties as pension fund trustees because they manage funds on the basis of specific statutory powers and duties rather than the pensions legislation and general trust law. And the second point here is that if one goes back to 4.79 and unpicks the proposition that the same rules which apply to pension fund trustees may be taken to apply to LGPS administering authorities, that appears to be based upon the assumption that the best interest duty in Article 18 of the IORP directive applies. And one can see the argument about that, and I don't think that that you need to read through it, but perhaps I can just tell you where the argument is to be found, starting at 4.69, going to 4.74 on pages 554 and 555. And we say that approach now has to be read with the unchallenged parts of the Court of Appeal's judgment in this case, to the effect that Article 18 of the IORP directive simply has no application to a state's interference with administering authorities' freedom to use non-financial factors at all. That's paragraph 35 of the Court of Appeal's judgment, core bundle, page 132. So I say one cannot spell out of the Law Commission's conclusions any proposition that the best interest duty means that administering authorities must be free to use any non-financial factors that reflect the views of scheme members without state interference. There's also an element of circularity about the reliance on some posited best interest duty in the case of a statutory scheme. One sees that from page 547 and paragraph 4.45 of the Law Commission paper, which sets out an extrajudicial and approves of an extrajudicial comment of Lord Nichols to the effect that the duty to act in the beneficiary's best interest was a formulation in different words of a trustee's duty to promote the purpose for which a trust is created. So in many ways, one is simply thrown back upon the question, well, what is the purpose? What are the purposes of this Act and these regulations? So there's as I say, there is an element of circularity about relying upon a best interest duty in these circumstances in the first place.
So are you saying that we should put a question mark against any alleged duty on the part of these administrators to act in the beneficiary's best interests?
Yes, if by best interests is connoted the same considerations that are required to be taken into account by public sector pension scheme trustees. It's obviously right, and I've taken you through the statute for these purposes to say that if you've got a funded scheme like this, quasi-fiduciary duties require the public law duties, Roberts and Hopwood, quite apart from the statutory scheme, would require the fund to be dealt with due prudence, etc. But that's not the same thing as importing a best interest duty from trust law. And if I may, I will end with a general point about the appellant's case. Because we say that the appellant's narrow approach to the purposes for which guidance can be issued results in an odd and illogical mismatch between the types of considerations that an administering authority can take into account under the statutory scheme and the type of guidance that the Secretary of State can issue. And we say that cannot have been intended by the Act. And there's a disguised contention in the appellant's case here, which is that the policy of the Secretary of State on non-financial factors is to be equated to the personal views of a fiduciary on moral or social issues, which are not a relevant consideration for investment decisions. And I say that's a false equivalence, because in pursuing government policy, the Secretary of State is not to be equated to a private pension scheme trustee pursuing their own interest. And in effect, that contention of equivalence turns the Secretary of State's guidance-making power into a dead letter, because what it means is that all the Secretary of State can really legitimately say is that administering authorities have to act consistently with the wishes of the majority of the scheme membership. It can deal with the nuts and bolts, the mechanics of how you decide whether a non-financial factor is or is not to be taken into account. But it can't say anything about what the non-financial factors should or should not be, even if government policy clearly has the effect that, in the government's view, it would be against the public interest to take account of certain factors rather than others. And I say that cannot be the proper effect of an act and regulations that are meant to cover a very wide variety of schemes where the Secretary of State himself or herself may be the scheme manager, and that has to work across the piece for all sorts of public sector workers. So, my ladies, my lords, for those reasons we say that the appeal should be dismissed, and unless you have any further questions, subject to checking.
Before the short adjournment, I raised with you in the guidance the passage which says the government has made clear that boycotts, divestment and so forth. And you said, because I said, what was the context in which the government made that clear? And you said that after the short adjournment, you would answer the question.
And, my lord, I have a note here, and thank you very much for reminding me. So, a public statement on the boycott policy was contained in the previous consultation on the regulations, November 2015. and the guidance itself follows materially identical wording in Procurement Policy Note 01 of 2016, issued by the Cabinet Office.
Is that the one we have?
It's not the one you have, my lady.
Could that be supplied?
It certainly could.
Thank you.
I thought Mr. McGaney, did Mr. McGaney not refer to that?
I think Mr. McGaney does refer to
But,
it. Yes.
we just don't have it in the bundle.
Yes, exactly.
Oh, I see.
Could you just give me the dates again? Give us the dates again, please.
Yes.
The consultation.
Yes, the consultation, the public statement was made on that in November 2015. And my lady, I will look that out as well and ensure that that is supplied. And the procurement policy note guidance is note 01 of 2016, issued by the Cabinet Office.
And that deals with this very self-same context of non-pecuniary investments by these administrators of the local government schemes.
Well, I mean, the procurement note is obviously issued in a different context.
Well, that was what I was wondering.
Yes.
It's described by Mr. McGaney, isn't it?
Yes.
At the second bullet point, you took us to the first. Is that the one? Page
So sorry, my lady.
253 at MS.
253.
Page 140 of the full bundle.
Yes, indeed. Yes. 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 So I will. I see that was actually exhibited to Mr. McGaney's statement, which I had not recollected.
Yes.
It was exhibited in the.
I don't think we've got it.
document.
Yes.
Thank you.
Thank you. Mr. Giffen.
Ladies, my lords, I'm going to structure the reply around my learned friend's 6 propositions and wrap up his points at the end into the 6th proposition. His first proposition, you'll recall, is the correct characterisation of the purpose. As to that, we say that Sir Ross Cranston at paragraph 29 on bundle page 146 is the factual finding about the purpose, and in any case, the Secretary of State's formulation, to the extent it's different, is clearly about broader political considerations, as Mr. McGaney expresses it. So that's the point. However exactly you formulate the purpose of the guidance, it is plain that it involves acting on the basis of broader political considerations. And the question is that lawful or not? So formulating it one way or the other in our submission doesn't really assist. What is perhaps of some interest here is the question I think my Lord Carnworth put to Melanie Fred about what the government is trying to do here, where it says no non-financial factor decisions in the field of defence and foreign policy, except where consistent with government policy. And however exactly the policy perspective of the Secretary of State may be formulated in answer to a question like that, what is plain is that it's not something that has anything to do with pensions. Defence and foreign policy are, as it were, given special status because the Secretary of State thinks it right to do so on defence and foreign policy grounds. So that is the fundamental point here. I think my learned friend also suggested it was about avoiding politicisation of the investment of the scheme, but in fact, because the Secretary of State's approach leads to precisely the opposite consequence, because instead of having a situation in which on our approach, the real constraint upon the administering authorities that it can only give as it were, expression to member views and not its own political policies, my learned friend's approach sweeps that away and introduces as a legitimate purpose for action the political policies of the administering authority or the government. And that's why, in answer to my Lord Wilson, my learned friend accepted that, if a new government impair new guidance, or as my Lady Hale pointed out, perhaps you just change the policy and it would in effect have to turn the investment policy on its head. If that is not a recipe for politicisation of the investment of the scheme, it's slightly hard to know what is. My learned friend's second point was to say that the starting point of the Padfield inquiry is the language used in the empowering section. With that, we don't disagree. He then went on to say, however, that in most cases it's the finishing point as well. We do dispute that. We say there is no authority for that proposition, and Spath-Holm is certainly not such authority. May I just take the court quickly back to three references in Spath-Holm. It is in the volume 1 of the authorities at tab 3, which is bundle page 468. And I will go first of all to Lord Nichols at page 516. I think the learned friend took you to what is on the facing page, 515. But if you look at page 516 at letter B, the starting point is that language is to be taken to bear its ordinary meaning in the general context of the statute. And that's the key point. Lord Hope, in my respectful submission, puts it very clearly at page 523, between letters E and H. The whole of that passage is worth, I say so, a look, but if I pick it up just above letter G, in some cases, he says, the point at issue will turn on the meaning to be given to a word or phrase in the enabling statute, which appears at first sight to be ambiguous. In other cases, the search for the true intent and meaning of the provision will raise broader considerations than the meaning to be given to particular words or phrases. The words or phrases which the enabling provision is used may in themselves be perfectly clear and unambiguous. That's Mr. Milford's point. On the face of it, the discretion may appear to be very wide. That's also Mr. Milford's point. The question will then be whether the width which the enabling provision bears according to its ordinary and natural meaning is limited by the context in which it appears when the Act is read as a whole, which is precisely the exercise on which all members of the House embarked on Spath-Holm, looking at the history, the policy and so forth. My third and final point from Spath-Holm is just to take you to Lord Justice Stuart Smith in the Court of Appeal, simply because he gives the longest citation from Lord Reid in Padfield. That's page 483 of the bundle. And it's at letters B to D. And Lord Selborne, in the Julius case, said that the question was whether it could be shown from any particular words in the Act or from the general scope and objects of the statute that there was a duty. So there is ample authority, says Lord Reid, for going behind the words which confer the power to the general scope and objects of the Act in order to find what was intended. So I don't for one moment dispute the relevance of the words in the enabling provision. I do say that any suggestion that that's a stopping point as opposed to a starting point is not only unsupported by, but directly contrary to the leading case. Then Learned Friend's proposition 3 was that the words used did involve a wide purport to confer a wide discretion. Well, we've dealt with that, but I invite the court to attach significance to Learned Friend's response to Lord Wilson's question about whether my friend accepted that my characterisation of the statutory provisions of being about the nuts and bolts of pension scheme. As I understood his response, he didn't dispute that characterisation. What he did say was that, yes, but it doesn't cut down the wide words. Well, so in a sense, it doesn't. It doesn't say Section 3.1 is limited to these things, but as we've just seen from Spathholm, this is an exercise in the overall impression is not quite the right word, but it is partly a matter of overall flavour. I think I've made the point. The other issue on the enabling provisions, in my submission, the Learned Friend doesn't really deal with at all, is the Regulation 7 point. And my submission is that Regulation 7 is not about the substantive power to invest. It is about a purely procedural focus on explaining your approach to investment, consulting on it. And I asked in my opening submissions, can it really be right that the Secretary of State's power to give guidance on a provision with an exclusively procedural focus allows him to cut back the legitimate choices of the authority in terms of its substantive investment decisions? And I say that the Learned Friend did not seek to answer that point. The Learned Friend's Proposition 4, he set out various purposes of the 2013 Act, the majority of which, of course, we have no difficulty with, and they correspond, as it were, to the unchallenged parts of the guidance. But the effect of the challenged part of the guidance is to override, as a possibility, what would otherwise be a lawful act of management of the fund. In other words, if the necessary member support and absence of financial risk is there, the authority could pursue these particular investment policies. And that possibility is taken away on the basis of policies which have nothing to do with pensions, as I've already said. So it is very hard to see how formulating the purpose has anything to do with the lawful management or administration of the scheme brings in those wider considerations. The Learned Friend's fifth proposition was the context. And he made, I think, 2 points. Here. One was that the Public Service Pension Schemes Act is concerned to deal with a wide range of public sector schemes. Well, so it is, but that takes one nowhere in answering the question, is the Secretary of State empowered by that Act to use his powers in relation to pension schemes to pursue broader policies having nothing to do with pensions? Simply, in my submission, begs the question. My learned friend's other point under his Proposition 5 was the financial significance of the schemes. And however, we would submit that the legitimate financial interests of the taxpayer are dealt with by the proposition arising both from the general law and encapsulated in the guidance that non-financial factors may not be pursued where that would risk material financial detriment to the scheme. And so since, by definition, we are in, if I can use a shorthand, a financially neutral position, it is again very hard to see how the financial significance of the pension schemes takes one anywhere in terms of whether that's a legitimate use of power. It is also, one ought to be clear, simply not right to say that the LGPS funds are ultimately funded by the taxpayer. They are funded they are funded by employer contributions. Some of those are, of course, indeed public body employers and therefore funded ultimately by the taxpayer, but there are also private sector employers in these funds who join under admission agreements. And also a very major part of the contribution comes from employee contributions. I take the point, as Milady, I think, said an argument, I mean, in a sense, they come out of the salary and the salary comes from the employer and the employer's funds come from the taxpayer. But to describe a contributory pension scheme as one whose costs ultimately are funded by the taxpayer doesn't give much weight to the well-established proposition that an employee's pension rights are part of his or her package of remuneration. And we've cited the Mr. Justice Lawrence Collins, as he then was in the AMP case, in our printed case, and that sets it all out very clearly. Finally, learned friend's proposition 6 about the mismatch. Now, this the allegation of mismatch really does all turn on the point about whether the administering authority in formulating an investment policy is acting as a fiduciary or not. If it is acting as a fiduciary, it is entirely clear in my submission that it cannot pursue its own interests or its own political opinions. What it can do, doesn't say it necessarily always has to do, but what it can do is give effect to member opinions. And if that's the right approach, then it naturally follows that explains why this is dealt with in Regulation 7, which is a process provision, because it's all about ascertaining member views, deciding to what extent you're going to give effect to them. And it is then the match, or as opposed to the mismatch, is that the Secretary of State's guidance similarly should be about these processes. Now, of course, if the authority is not acting as a fiduciary, if it's simply making the investment decisions, as it were, entirely in its own right as a local council or a public authority, then, well, I accept that my learned friend's argument would have traction. But in my submission, my learned friend has said not one word that would in any way support a suggestion that a body charged with the management of a discrete fund, and it has to be a discrete fund under statute from which others benefit, acts in relation to that fund in anything other than a fiduciary capacity. And if you read the Law Commission report, you will see that it is not based upon the IORP1 directive. It is, and we have put in our printed case in the bundle, cases that hold clearly that the administering authority does have fiduciary duties. The BAA case at pages 828 and 834 of the bundle is the closest example. If I may just finish by dealing with the Bain case, which my learned friend mentioned. That is not a case that addresses the question of fiduciary duties at all. It's a case that holds that there is no trust as such in a local government pension scheme situation, or the Scottish equivalent. And the reason why they had to decide whether there was a trust stricto sensu was that trust-based schemes had a particular statutory requirement for member-nominated trustees. Statute-based schemes did not and don't. They held it wasn't based on a trust stricto sensu, so that requirement didn't apply. And that is all that case is about. My lady, unless Mr. Sewell is about to tell me I have missed a critical point, I think all that remains to say on that subject is that although it is rather surprising, by way of conclusion, that in an attempt to justify the Secretary of State's guidance, the department should, in this court, take the position, as my learned friend did, that there is not an obligation to act in the best interests of scheme members, and that whilst it may be a good idea for the administering authority to do so, they at any rate question whether there is any legal obligation. We say that there is such an obligation, for which best interests is a shorthand, and it derives from the fact that the legislation is such as to constitute a fiduciary relationship, and from that, in our submission, all else follows. I think that's probably my 15 allocated minutes, but if I've left any point untouched...
It's a little bit more than that.
Was it? I'm so sorry. I do apologise.
I regret to have to inform you, but there we are. I see no further questions. Thank you. Well, thank you to everyone, both for what has been said on paper and what has been said on your feet. We know a lot of work goes into this by people from whom we don't always hear, although I suspect in the case of Mr. Milford, he did both jobs. But thank you all anyway, and we will go away and scratch our heads and let you know what answer we come up with in due course. Thank you. Court will now adjourn.